Yoshi, before I approach, I wish to just explain how my submissions, the sequence of my submissions, Yoshi. I first plan to give a brief detail or exposition of the applicable laws in relation to bail applications, and then I move on to a brief explanation of the facts. By the facts, I mean what led to accused 1, 2, and 3 to be here on the 5th of August 2024. And then I attempt to apply the laws and the principles outlined to the facts to try and show this court that accused 1, 2, and 3 should not get bail, not eligible for bail. Beginning with the exposition of the law, Your Worship, the starting point in every bail application is Section 35, subsection 1, paragraph F of the Constitution, which states that everyone who is arrested for allegedly committing an offense has the right to be released from detention if the interest of justice permits, subject to reasonable conditions. This section of the Constitution is given statutory effect in Chapter 9 of the Criminal Procedure Act 51 of 1977. Thus, Section 60, subsection 1, paragraph A of Chapter 9 of the Criminal Procedure Act 51 of 1977 states that an accused person in custody in respect of an offense shall be entitled to be released on bail at any stage preceding his conviction in respect of such offense, unless the court finds that it is in the interest of justice that he or she be detained in custody. Therefore, from the above, it appears clearly that the power to grant or refuse bail is essentially a judicial one, and that the court will lean in favor of liberty and grant bail where possible, provided the interest of justice will not be prejudiced by this. Put simply, bail may not be refused unless there are sufficient grounds for believing that the accused will fail to observe the conditions of his bail. Section 60, subsection 4 of the Criminal Procedure Act provides that it will not be in the interest of justice to release an accused person on bail where one or more of the grounds listed in paragraphs A to E are present. Such grounds include A, where there is a likelihood that if released on bail, the accused will endanger the safety of the public or any particular person, or will commit a Schedule 1 offense, or where there is the likelihood that the accused, if he or she were released on bail, will attempt to evade his trial, or where there is a likelihood that the accused, if he or she is released on bail, will attempt to influence or intimidate witnesses, or to conceal or destroy evidence, or this is D, the preceding one was C, this one is D, the subsequent one, where there is the likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. And lastly, E, where in exceptional circumstances there is the likelihood that there is the likelihood that the release of the accused will disturb the public order or undermine the public peace and security. Now, Your Worship, the state submits that in this current application for bail before this honorable court, there are several factors which indicate that almost all the grounds listed from paragraph A to E above are present, and therefore it would not be in the interest of justice for any of the accused persons to be granted bail. Bishop, for convenience, I wish to refer to them as accused persons. I understand the applicants, Your Worship. I don't want to confuse myself. Okay, and then moving on to the next point in law. as it is common cause between the state and the defense that this is a Schedule 5 application for bail, Section 60, subsection 11, paragraph B, shifts the burden of proof in that the point of departure, owing to the charge or charges preferred against the accused, is that it will not be in the interest of justice for any accused persons to be granted bail unless such accused person can show that, or rather can show by way of evidence to the court that his release on bail will not undermine the interest of justice. Thus, evidence must be produced by all accused persons that if released on bail, it is unlikely that they will endanger the safety of the public or any particular person, or commit a Schedule 1 offense, or attempt to evade their trial, or rather not even or and attempt to influence, or rather, let me just start again. The first one, it is unlikely that they will endanger the safety of the public or any particular person, and it is unlikely that they will attempt to evade their trial, and it is unlikely that they will attempt to influence or intimidate witnesses, or to conceal or destroy evidence, and it is unlikely that if released on bail, they will jeopardize the proper functioning of the criminal justice system, including the bail system. And lastly, it is unlikely that their release will disturb the public order or undermine the public peace and security. The state submits that no sufficient evidence was led by any of the accused persons which can lead this honorable court to the conclusion that none of the sections, or rather none of the Section 60, subsection 4, paragraph A to E considerations are likely to materialize should the accused person be granted bail. Now, moving on to the facts of the case, Your Worship. As we all know that there's video footage circulating in social media everywhere, be it Twitter, WhatsApp, Facebook, where it is shown that accused number 1, accused number 2, accused number 3 entered a primary school in the township of Katlehong, wherein accused number 1 was wielding machetes, 2 machetes or pangas. Accused number 2 is believed or is seen there with a rifle, what may be perceived or understood to be an AK-47. Accused number 3 is seen dragging 2 kids out of an office building in the premises. Now, firstly, in the state's affidavit, it's indicated that there were 2, there's video footage, there's another video footage which may not have gained such popularity as the first one, but then there's a video footage, the state is in possession of a video footage showing that accused number 1 also had another rifle in his boot. Took out that other rifle, he is seen discharging that rifle to disperse people who were in public, or rather in the streets, so that he can drive and leave the crime scene. Now, Your Worship, that place where they were is a primary school. Kids there, Your Worship, just to put things into perspective, some of the kids there a few months ago were in nursery school crash, Your Worship. And it is seen that accused 1, 2, and 3 were carrying AK-47 in front of crash kids who were in crash a few months ago. Just last year ago, they were in crash. Some of these kids have never seen a gun before. Some of these kids have never seen a machete before. But the video footage that is circulating indicates that they were exposed to that by accused 1, 2, and 3. Now, in applying the facts, Your Worship, in applying the law to that short piece of fact, Your Worship, Section 4A, the question which needs to be asked as to whether it would be in the interest of justice for accused person to be released on bail is there a likelihood that if released on bail, accused persons will endanger the safety of the public or any particular person or commit a share of one offense? Now, the evidence before, or rather, which the state has, indicates that accused 1, 2, and 3 have no permit, have no license to carry rifles, Your Worship. These are wartime weapons. They carried wartime weapons at a primary school, Your Worship. Now, one rifle was taken, or rather located, and was taken away from the accused persons. The other one, which was in the boot, has not been located by the police. It's still with accused 1, 2, and 3. So meaning they are still in possession of an unlicensed firearm, which is concealed somewhere. I don't know where, because we don't know where accused number 1 lives, judging by his multiple premises that he gives. So, Your Worship, the question that the court needs to ask itself is, will release or on bail of accused 1, 2, and 3, will it not endanger the safety of the public, Your Worship? These are people who have the brazen audacity to go to a primary school with guns, rifles, AK-47s, and expose kids to AK-47s. And there's another gun that's still circulating amongst them that hasn't been located. If the court releases accused 1, 2, and 3, and they have, and furthermore, Your Worship, this also has to be emphasized, they are not skilled to be carrying AK-47s. They have no permit, they have no license. They never went to training to carry AK-47s, and yet they went to a primary school unskilled to carry AK-47s and put the lives of primary school kids in danger. These are the people who want to go out on bail, who still have a rifle that is illegal circulating somewhere. So, Your Worship, in the state's view, Section 60, subsection 4, paragraph A has been met, Your Worship. There's a likelihood that if released on bail, there's actually more than likely they will endanger the public, Your Worship, especially given the fact that they've got that boldness. So accused number 1 is prominent relatively. Knowing that people are taking video footage of what he was doing, his antics there, he still nevertheless went ahead. I mean, he was so brazen. So if a person is so confident and audacious enough to commit a Schedule 5 in public, what more a Schedule 1 in private? I mean, you might as well just committed it anytime. So, Your Worship, in the state's view, these are dangerous people. They will endanger the safety of the public. Releasing them on bail will prejudice the interest of justice, Your Worship. It's not in the interest of justice that accused 1, 2, and 3 be released. Now, as having given the facts, Your Worship, I move on to Section 4. Your Worship, just to state not only the facts, but factors and considerations which emerged after accused persons have been arrested. The first one being that for purposes of bail, they had to give their residential addresses to the investigating officer so that that can be verified, so that should they be granted bail, they can be easily pinned down to a particular place, and the court can, or rather the state can, know where they are should they not come to court. They can just go there and arrest them. So these are considerations which emerged after they were arrested. And 1, 2, and 3 provided details pertaining to their addresses and where they reside. And 1 and 3 said they reside Gumede Street somewhere in Albamali. And they gave that information to the investigating officer, saying we reside Gumede Street. There's a name, there's a number. It's given, Your Worship. It's on record, Your Worship, as I was reading the affidavit. There's a house number given, the street name, and the area, Albamali. The police went there to go verify the address, only to find that that place doesn't exist. Doesn't exist whatsoever. And actually, that place is a complex. Well, Albamali, that suburb, where it's indicated, it's a suburb. As they went there, the security guards, before even going inside, the security guards told the investigating officer, listen, there is no Gumede Street here. I've been working here for some time. There's no Gumede Street. However, the investigating officer still said, you know what, let me go there and check for myself. Drive around, using scarce state resources to drive around looking for a street that does not exist, only to find that indeed that street doesn't exist. And so we still currently don't know where accused 1 and 3 reside. Accused 1 has a tendency of he's been before courts on criminal or in relation to criminal matters several times. The affidavit indicates that it's about 9 times where there's been cases opened against him and such matters have been withdrawn. However, and furthermore, in those 9 times, he's given 9 different addresses. And now his son vouches for him, or accused number 3, in a way vouches for him and says, no, actually I'll also live where my father lives, at a non-existing address. So, we don't know where accused 1 and 2 lives, accused 1 and 3 lives. Accused 2 initially said, I live in Boksburg, Marbleton, Boksburg. When the investigating officers went there, yes, there is a place like that, Marbleton. There is a house number that's in line with what he gave the investigating officer. The neighbor confirmed, he wasn't there, the neighbor confirmed that yes, indeed, such a person resides here alone, which is also a bit of a concern. If a person lives alone, it might be a little bit too easy for him to just locate and be untraceable. However, now in his affidavit, I note that when he gave where he resides, he gave a different place now where he resides. Instead of saying I reside at Marbleton as being the place where you had gone as a state to confirm as being my residential address. Now he comes and says, no, I reside at number 3 Garfen Avenue, extension 2, Albamali 1401, at the place of my employer. The same employer which we do not know where he lives, who's got several addresses and And last week Friday, I don't know why the foresight of giving another address. On the same day, he gave another address, gave the court another address. So he's been giving several addresses in his track record. Now, accused number 2 says, no, I reside with this person who's giving several addresses. So now, coming to section 4, or section 60, subsection 4, paragraph B, which indicates that it would not be in the interest of justice for accused persons to be released if, or rather where there is a likelihood that the accused, if he or she were released on bail, will attempt to evade his or her trial. Now, a proper interpretation of section 60, subsection 4, paragraph A is given by way of having regard to considerations which are enlisted or listed under section 60, subsection 6 of the Criminal Procedure Act. No one really knows where he lives.